Advisory Opinion on Western Sahara 1975. The General Assembly sought advice on the following issues on December 13, 1974 from the ICJ. 1. Was Western Sahara at the time of colonization by Spain a territory belonging to no one? If the answer to the first question is in the negative. 2. What were the legal ties between this territory and the Kingdom of Morocco and the Mauritanian entity? For the first question, ICJ held that the native Western Saharans inhabited Western Sahara in 1885. Meaning that in 1885, the Sahrawi people of Western Sahara had the position of sovereignty. So the answer was no. Then ICJ moved to second question. What were the legal ties between this territory and the Kingdom of Morocco and the Mauritanian entity? Morocco argued that there are internal and external recognition of Moroccan sovereignty. The court has been presented with Morocco's claim to legal ties with Western Sahara at the period of Spanish colonialism as a claim to ties of sovereignty based on a supposed immemorial possession of the territory. It claims that this immemorial possession was founded not on an isolated occupation, but on demonstration of sovereignty and public, many centuries, without disruption or dispute. Morocco referred a series of events stretching back to the Arab conquest of North Africa in the 17th century AD. ICJ held that the historical information is rather ambiguous as proof of possession of the land in question because many of these occurrences were distant, sporadic, and frequently fleeting. Further concerned the legal states of Eastern Greenland. ICJ held that Western Sahara sparsely populated and a territory across which socially and politically organized tribes were in constant movement and where armed incidents between these tribes were frequent. Then concerned the relevance of special structure of Sharifian state. The Moroccan Sultan was acknowledged as the supreme ruler in regions outside of direct governmental control, Bilad al-Siba, based on his spiritual authority, Amir al-Mu'minin. However, evidence do not dispense the court form appreciating whether at the relevant time Moroccan sovereignty was effectively exercised or displayed in Western Sahara. Sultan and Sahrawi leaders, al-Qaid, ties of allegiance, Da's link to Tina tribal leaders was also rejected. Notwithstanding the accounting for the particular Sharifian state structure, the ICJ was unable to discover any tie of geographical sovereignty. In Western Sahara, Morocco had not displayed effective and exclusive state activity. The court must then determine whether the international acts cited by Morocco has any impact on its understanding of the legal situation that emerges from a review of the international acts invoked by Morocco to demonstrate that the Sultan's authority was acknowledged either directly or indirectly, encompassing the area to the south of the Naun and the Dra. Under that a series of Moroccan treaties were concerned. In a treaty with Morocco in 1861, Spain acknowledged Sultan's dominance over the Sahrawi tribes, for example, Esmeralda case. ICJ held that it demonstrates that they should be interpreted as being concerned with the Sultan's power or influence in Western Sahara only in terms of personal ties to some of the area's nomadic tribes. Morocco and England signed a treaty in 1895 recognizing Moroccan sovereignty. However, Moroccan interpretation not supported, the court came to the conclusion that there was no connection between the Western Sahara region and the Kingdom of Morocco or the Mauritanian state as a result of the documents and information provided to it. Thus the court did not find any legal ties of such a nature as might affect the application of the General Assembly's 1960 Resolution 1514-15, containing the Declaration on the Granting of Independence to Colonial Countries and Peoples, in the decolonization of Western Sahara and, in particular, of the principle of self-determination through the free and genuine expression of the will of the peoples of the territory.